And welcome back. Will Worsham joins us now for this week's Speaking Legal Discussion. Good to see you again.
Hey, good to be here.
Are you all ready for this?
I'm ready for this.
All right, here we go.
So are we.
We made a revocable trust to make sure our medical care costs don't take our house. Is that what we need? All right, that's, I would
Where
think,
do we
a simple
start?
answer, but
Well, it's a common misconception. It's really close.
yeah.
Because you do protect your assets with a trust, but it's an irrevocable trust. And so we do a lot of estate planning with revocable trusts because they do avoid probate, they give a lot of flexibility.
You can change that one. We've talked about that.
Yeah, you can do great things with trusts. We love trusts for estate planning. They're a really wonderful tool, but they do not, revocable trusts do not provide creditor protection because you are still in control of everything in that trust. So in order to have assets not be subject to creditors like Medicaid, like hospitals, you can't own them anymore. They can't be in your control. And so you either have to give them away outright to somebody else.
Right.
Sometimes people will do that. They'll do gifting plans for their children. But if you need to retain at least beneficial interest in that property so that you can live in the house, so that you can maybe draw income, you can place them in an irrevocable trust. Now, the way I like to talk about that is a revocable trust is kind of like a bucket. You're putting everything in the bucket. The top of the bucket is open. You can put things in. You can take things out. All that works great.
And do you have to name someone to control that?
Every trust has to have a trustee.
A trustee,
yeah.
right.
So someone does have to control that bucket, but you typically name yourself as the trustee of the bucket.
Okay.
Because you're managing it for your own benefit. You're managing it for yourself. An irrevocable trust, I kind of like to talk about as being more like a lockbox.
Yeah.
You put things in it through the slot, but you can't get things out unless you have a key to the lock. And you have to give that key to somebody else. Then you no longer have control over those assets. Somebody else does, whoever you've given the key to. Maybe your kids, maybe a professional advisor.
But that person has to follow your wishes.
Right,
though.
you created the lockbox, and
Right.
so you get to set the rules for that lockbox. So the rules for that lockbox can be, hey, my house is in the lockbox, I get to live in the house. I'm putting a significant amount of my financial assets in the box. Trustee, I want you to invest them. In fact, trustee, I want you to use this particular financial advisor to invest those assets, and I want you to pay me out the income, but never give me the principal except in certain circumstances.
Right.
If I really, really need it. And so that way the trustee can say, yes, we'll spend the money for that, for a new car, maybe. You need a new car. Okay, I'll spend the money for that. Somebody comes and says, well, I want you, trustee, to pay for their health care. The trustee can say, no, I'm not paying for their health care. They can't pay for the health care. Now, there are some time limits and rules about when you create these things.
There have to be rules. There's a certain amount of time before this all kicks in.
Right. You can't do what's called transfers and fraud of creditors. So if you know there's a creditor coming, if you know there's a judgment against you, you can't transfer the assets just to get out of paying a judgment. But typically 3 to 5 years, depending on the creditor, if you've transferred the assets out of your possession, then they're going to be out of the reach of a creditor because generally speaking, we're assuming that 3 to 5 years out, you're not anticipating a judgment, a particular judgment. I mean, obviously, you create these in anticipation of the possibility of a future judgment or creditor. That's one of the reasons you would create an irrevocable trust for creditor protection. But as long as it's not an imminent creditor, then there's really not too much of an issue. And 3 to 5 years tends to be the window we're looking at.
Wow, get some good advice. And if you have a legal question for Will, email him at wworsham@color10.com. He'll answer your question on the show. Thanks so much, Will.
Hey, glad to be here.
All right, up next, move over, Will. Your money-minded sidekick, Bruce Porter, is here for Dollars and Cents right there. We'll be right